Okay, let's really get into this. We're looking at a case that, well, it's got all the elements, hasn't it?
It really does. A classic industrial daddle, you might say.
Yeah, starting with 22 coal miners. Ordinary guys working down at the Metropolitan Coal Mine near Helensburgh, New South Wales.
And these weren't casual workers. Many were long-term employees, skilled tradespeople, electricians, maintenance crews, people vital to keeping that mine running. Neil Bartley, an electrician, he's the name that leads the case, but he represents all 22.
People whose lives are tied to that place, that work. Specifically, a lot of them worked on the conveyor belts, right? The arteries of the mine.
That's right. Servicing, inspecting, maintaining those critical systems that haul the coal out. It's tough, skilled work.
And then, bang, a decision comes down from the company, Helensburgh Coalbody Ltd., early 2020.
Not about safety, not about the coal running out, but a strategic shift. They decided to reorganize.
Reorganize how?
Specifically, how the work on those underground conveyor systems was done. The servicing, inspection, auditing, rectification, all that stuff. They decided to outsource it, give that work to an external contractor called Menser, starting around April 2020.
And they already had other contractors on site.
They did, yeah. A company called Nexus was doing other work, so using contractors wasn't totally new. But this specific move, taking work their own employees did and giving it to Menser, that was the trigger.
And this is all happening against the backdrop of, well, early 2020.
Exactly. COVID-19 hits, the global economy is shaking, and the price for coking coal takes a dive. Significant financial pressure on the company, no doubt.
So you can imagine the atmosphere. Rumors flying, uncertainty, management starts consultation meetings.
Yes, with the employees and their union, the Mining and Energy Union, the MEU, and the MEU is crucial here. They backed these workers all the way through what turned into a very, very long fight.
And during these talks, the workers themselves, they see what's happening. The conveyor work still needs doing.
Absolutely. It wasn't like the work disappeared, so they put forward a pretty logical suggestion, didn't they?
They did. They basically asked management, look, if this work still needs doing, why not let us do the contractors' work instead? Keep us employed.
It seems straightforward. They're saying, we have the skills or we can get them quickly. The work is right here. Keep your own people on.
But the evidence that came out later suggested that management, well, they weren't really receptive.
That's putting it mildly. The phrase used in the findings was that the pleas fell on deaf ears. Management apparently flatly rejected the idea at the time.
And did they even, properly look into it? Do a study?
Apparently not. No formal feasibility study at that point to see if having their own workforce take over tasks from Nexus or Menser was practical. They agreed to insource some other minor things, but it wasn't enough to save these 22 jobs.
So the axe falls, June 2020.
Yep. Collective dismissal, 22 employees let go. The reason given, operational reasons.
But for the workers, it must have felt like they were just being swapped out.
Precisely. The job's still there, someone else is doing it, but we're gone. That feeling of unfairness, that's what kicked this whole thing off.
And they didn't just walk away.
No way. Just a month later, July 2020, led by Neil Bartley, backed by the MEU, they lodge unfair dismissal applications with the Fair Work Commission, the FWC.
And that's where this legal epic really begins. Stage 1, the Fair Work Commission.
Right. The FWC is Australia's national workplace tribunal. It's the main place you go for these kinds of disputes. Under the Fair Work Act, the FWC can order remedies if a dismissal is unfair. Things like getting your job back or compensation.
But there's a catch. A big one for the company.
A very big one. Section 385 of the Act outlines what makes a dismissal unfair. But subsection D is crucial. It says a dismissal is not unfair if it's a case of genuine redundancy.
So if the company could prove this was a genuine redundancy,
then the unfair dismissal claims would just evaporate. The FWC wouldn't even get to consider if it was harsh or unjust. Game over, essentially, on that claim.
And the law actually makes this the first hurdle, doesn't it?
It does. Section 39060. The FWC has to decide, up front, was this a genuine redundancy? Only if the answer is no can they proceed to the merits of the unfair dismissal claim.
So this preliminary question became the whole fight initially.
Absolutely, the entire focus. The case landed with a single member, Commissioner Riordan. Sensibly, he decided to hear all 22 applications together.
Okay, first round. The workers' corner.
They had a strong legal team, instructed by the MEU, led by senior counsel Mark Gibeon, assisted by Philip Boncardo. Their argument was aimed squarely at Section 389, subsection 2 of the Act.
What does that subsection say?
It says a dismissal is not a genuine redundancy if it would have been reasonable in all the circumstances for the employee to be redeployed within the employer's business or a related business.
Right. So the workers argued.
They argued it would have been reasonable to redeploy these 22 guys into the roles being done by the contractors Nexus and Menser right there at the mine. They said the company failed to properly explore this, pointing out the workers had the skills for the conveyor work Menser was doing.
And the company's response. Helensburgh Coal.
Represented by the major law firm Minter Ellison, they argued, no, these were genuine redundancies. The operational changes meant the specific jobs these 22 men held were no longer required by the company.
And the redeployment point. Section 389(2).
They argued that reasonable redeployment only applies to existing vacant roles within the company's structure at that time, or maybe roles definitely coming up soon. It didn't mean, they argued, that the company had to hypothetically restructure itself, kick out contractors just to make space for redundant employees. That went too far.
Okay, so the arguments are laid out. Commissioner Riordan hears it all. Decision time.
November 2020. A nightmare for the miners.
Wow. First round to the workers.
Big time. Commissioner Riordan found the dismissals were not genuine redundancies. He explicitly concluded it would have been reasonable for the company to insource work from Nexus and Menser and put their own employees into those roles. He looked at everything, the work still being there, the skills, and said the company hadn't met that reasonable redeployment test.
That must have sent shockwaves through the company.
You'd imagine so. It directly challenged their operational decision-making. So, unsurprisingly, they appealed immediately, straight up to a full bench of the Fair Work Commission.
So, moving up the ladder within the tribunal system.
Exactly. This time, a panel of 3 senior members. Vice President Joe Catanzariti, Deputy President Ingrid Bissett, and Commissioner Danny Wilson. A more, shall we say, August setting?
And the company's argument on appeal.
Mm-hmm.
Still Minter Ellison representing them?
Yes, still Minter Ellison. Their appeal focused heavily on Commissioner Riordan's handling of Section 389(2). They argued he'd used the wrong legal test for reasonable in all the circumstances. They claimed he'd made errors like wrongly considering if keeping contractors while sacking employees was reasonable and getting the facts wrong about how feasible insourcing actually was.
And the workers' team. Gleeson SC and Boncardo again?
Yes, instructed by the MEU. They defended Riordan's decision vigorously. Philip Boncardo apparently took the bench through the nitty-gritty facts, the consultations, the contractor work. Mark Gleeson SC argued the big principle. Section 38922 has to mean the FWC can look at everything, and everything includes work being done by contractors on the same site that your own people could do.
Their point being, you can't just outsource your way out of redundancy obligations.
That was the essence of it. They argued the company's narrow interpretation would create a massive loophole. And they pointed to the company's actions renewing a contractor deal after the dismissals, rejecting insourcing without a proper look as undermining the idea that the redundancies were truly unavoidable.
Okay, the full bench, here's the appeal. What was the outcome this time?
This was May 2021. The decision was, well, you could call it mixed, but with a very important win for the miners on the core legal point. Crucially, the full bench agreed with Commissioner Riordan's broad interpretation of the law. They explicitly stated that when you're assessing reasonable redeployment under 389(2), looking at whether work could or should be insourced is a necessary matter to decide.
That's huge. So they rejected the company's argument that contractor roles are off limits.
Completely. They said, no, the presence of contractors doing work the employees could do is relevant. That was a massive victory on the legal principle.
But you said it was mixed.
Yes. While they agreed with Riordan's understanding of the law, they found a flaw in how he applied that law to the specific facts in his first decision. They felt one particular factual conclusion he reached about the reasonableness of insourcing from one of the contractors wasn't quite backed up by the evidence presented at that initial hearing.
Okay. So win of the law, but a stumble on the facts.
Kind of. So they upheld the legal principle, a big win. But they quashed Riordan's actual decision and sent the case back to him, a remittal. Basically telling him, okay, the legal approach is right. Now go back and reevaluate the factual question of reasonable redeployment properly using this legal guidance.
Back to square one, almost, but with a legal rule clarified.
Exactly. A procedural setback, but the key legal argument had been won by the workers at this stage.
So the case lands back on Commissioner Riordan's desk just before Christmas 2021.
That's right. He holds another hearing, considers the evidence again, now with the full bench's legal ruling clear.
And his decision this time? The third decision in this saga.
December 2021, he fines for the miners again,
It's all
completely.
double down.
Pretty much. He stated he was even more convinced that redundancies weren't genuine. He went through the feasibility evidence again. He highlighted things like the Nexus contract expiring literally 10 days after the sackings.
Very convenient timing to argue redeployment wasn't possible.
Right. And the Menser contract was described as a flexible standing offer, no guaranteed minimum work, meaning the company had a lot of control, could easily wind back Menser's work to make room.
So he found it was feasible and reasonable.
Yes. He concluded the workers had the skills, or needed minimal training, and dismissed the company's worries about business disruption, given how flexible the contractor setups actually were.
The company must have been pulling their hair out, lost twice before the same commissioner.
You can imagine the frustration. So January 2022, what do?
Heal again.
Appeal again back to the FWC full bench. Same grounds, essentially. Riordan just got the facts wrong, made unreasonable findings. Still Minter-Ellison acting.
And the tone of this appeal.
Sources suggest it was somewhat exasperated, basically saying, come on, he's just wrong on the facts, you have to step in.
So the same full bench panel hears it again. Catanzariti, Bissett, Wilson.
Yes, the same trio. This is now the fourth FWC decision point in this dispute, March 2022 hearing.
And the outcome in the second appeal.
Decision delivered September 1st, 2022. Appeal dismissed.
The miners win again.
They do. The full bench acknowledged Riordan might have made some minor factual slips, but said they were not significant. They pointed out Section 400 of the Act limits their power to overturn factual findings unless there's a major error.
And did they endorse his reasoning this time?
Wholeheartedly. They fully backed his core conclusion. It was reasonable to redeploy some, if not all, of these workers into the contractor roles. They stressed the work wasn't highly specialized, any training was minor, and the necessary reorganization was within what a reasonable employer should consider.
And crucially,
they hammered home the point. Just because contractors are doing the work doesn't give the employer immunity from considering redeployment for their own staff under Section 389(2).
So after 4 FWC decisions over years...
4 years, yeah. All landing in favor of the miners on the crucial genuine redundancy point. The FWC chapter closes with a clear message. These were not genuine redundancies. The path was now clear for the actual unfair dismissal claims to be heard on their merits, reinstatement, or compensation.
But Helensburgh coal, they weren't done yet.
Not by a long shot. They decided to take an extraordinary step. They escalated out of the tribunal system into the federal courts.
How? This wasn't just another appeal.
No, this was different. November 2022, they filed for judicial review in the full Federal Court of Australia.
Judicial review. That's not about whether the decision was right or wrong on the facts, is it?
Exactly. It's about legality. Did the FWC follow the law? Did they act within their proper power, their jurisdiction? Or did they make a fundamental error of law, like misinterpreting Section 389 so badly that their decision was invalid?
So the company, still with Minter-Ellison, was arguing the FWC basically got the law wrong, fundamentally.
Yes. They wanted the federal court to quash all 4 FWC decisions on the basis of legal error and jurisdictional error, saying the FWC had misunderstood its role and powers under the Act.
That sounds like a high bar to clear.
It is. Courts are usually hesitant to second-guess expert tribunals like the FWC unless there's a clear legal mistake. It was definitely a bold gambit. But the stakes were huge: potential reinstatement, big payouts, and that precedent about outsourcing.
So who heard this in the federal court?
A panel of 3 judges, Justices Katzmann, Snadden, and Reaper. They had to grapple with these complex legal arguments about Section 389(2), and also about the correct standard of review the FWC full bench should have used.
And this is where that moment happened, the manager's testimony.
Yes. During the federal court hearing, under cross-examination, a Helensburgh manager was asked point blank, did the company seriously consider letting the contractors go to keep their own employees?
And the answer?
The answer was no, not seriously. It's just not how we approached it.
Wow, it's just not how we approached it.
That start. It really is. It crystallizes the whole conflict, doesn't it? The company saw it as a straightforward operational decision. Outsourcing is how we do things now. The workers saw it as a failure to even consider a reasonable alternative that would save their livelihoods. It highlights that tension perfectly.
So the federal court judges hear all this, consider the legal arguments.
And on April 5, 2024, they deliver a unanimous judgment.
The verdict.
Application dismissed completely. Helensburgh coal lost. The federal court found no legal or jurisdictional error in the FWC's decisions.
What was their reasoning on the main point, Section 389 and the contractors?
They firmly backed the FWC full bench. They said Section 389(2) does qualify the genuine redundancy defense. It does authorize an inquiry into steps the employer could have taken, including steps that could reasonably lead to redeployment. And crucially, they said there's no reason to excise from all of the circumstances the work being performed by contractors. The FWC was acting legally.
So a huge validation of the SWC's approach from the federal judiciary.
Absolutely. And they also dealt with that other legal point, the standard of review. The company argued the FWC full bench should have demanded correctness from Commissioner Riordan's decision.
But the federal court said,
They disagreed. They said deciding reasonableness in all the circumstances under 389(2) is an evaluative determination. It involves value judgments, opinions. There isn't always one single correct answer.
like judging if something's fair, there can be a range of fair outcomes.
Exactly. So they said the right standard for the FWC full bench to use on appeal was the standard for reviewing discretionary decisions, the House v. the King standard, which is more differential. You only overturn it if there's a legal error or the decision is clearly unreasonable outside the acceptable range, not just because you'd have decided differently.
And they cited precedent for that.
They did. They referred back to a high court case, Cole and Allied from 2000, suggesting this approach fits with how industrial law appeals have historically worked for these kinds of evaluative judgments.
So on both counts, the meaning of 389 here and the standard of review, the federal court sided against the company.
A comprehensive defeat for Helensburgh Coal in the federal court. Their response, the parent company Peabody Energy, was muted disappointment, reviewing the judgment. Minter Ellison still on board. The MEU and the workers, obviously, vindicated again.
But surely that's the end of the road, FWC, federal court?
You'd think so. But no. There was one last option. The highest court in Australia.
The High Court. They decided to try for the High Court.
They did. In May 2024, Helensburgh Coal applied for special leave to appeal to the High Court of Australia.
And getting special leave isn't easy, right? You have to show it's a really important case.
Exactly. A matter of public importance or a significant legal principle that needs clarifying. Many people probably thought, would the High Court really take this on after the FWC and federal court rulings?
But they did.
Surprise, surprise, yes. September 5, 2024. Special leave granted. 7 justices agreed the case raised questions important enough for the High Court to hear. Gagler CJ, Gordon, Edelman, Stewart, Gleeson Jaggett, Beach-Jones JJ. The final act was set.
So the scene shifts to Canberra, the High Court, March 6, 2025.
The ultimate legal showdown. Helensburgh Coal, Plitty, Ltd v. Bartley and Orrs, heard by a bench of 5 justices this time. Chief Justice Gagler, Justices Gordon, Edelman, Stewart, and Beach-Jones.
And the legal teams, still the same?
Mostly, but with some very heavy hitters leading. For Helensburgh Coal, still instructed by Minter Ellison, the lead counsel was Bret Walker SC, one of Australia's most respected barristers, with AM Pomeranke Casey and PM Zielinski.
And for Neil Bartley and the other miners?
Instructed by the MEU, their team was led by the former Commonwealth Solicitor General JT Gleeson SC, with Philip Boncardo, who'd been involved right from the FWC stage. The FWC itself also made submissions.
Okay, so Bret Walker SC for the company kicks things off. What was his main line of attack?
He went straight for the objects of the act, arguing the whole FWC approach here felt jarring compared to the aim of quick, flexible, and informal procedures for unfair dismissals. He suggested this deep dive into hypothetical insourcing was just too complex and burdensome.
And on the core legal point, Section 389(2),
he pushed the argument that reasonable redeployment has to be limited to the employer's enterprise as it actually exists at the time, or maybe imminent planned changes, but not, he argued, requiring the FWC to imagine a different business structure where contractors are gone. The enterprise might be dynamic, he conceded, but 389(2) looks at the present state, not a hypothetical one the FWC might prefer, by unwinding the employer's business judgment.
trying to keep the focus narrow on the company's actual setup.
Yes, he also tried to distinguish redeployment under 389, the threshold question, from reinstatement under Section 391, the remedy. Different concepts, different stages.
How did the justices react to that?
They pushed back. Chief Justice Gagler questioned the timing aspect. Justice Gordon asked, well, if your argument holds, does that mean an employer doesn't even have to consider minor changes, like adjusting hours, if the job isn't identical? Justice Beach-Jones questioned whether looking at deploying someone to a different job, like one a contractor holds, isn't exactly what 389(2) is for.
Walker SC stuck to his guns.
He did, maintain that looking beyond the existing structure to displace contractors was going too far, taking the enterprise as you find it.
Okay, and his second big argument, the standard of review.
He argued the federal court got it wrong applying House v. the King. He said the 389 decision is a critical jurisdictional getaway. It demands a definite yes-no answer, and there is a single uniquely correct answer, even if it involves judgment.
So he argued the standard should be correctness. The appeal court should decide if the original decision was the only right one.
Precisely. And applying the more relaxed House v. the King standard was, he argued, itself a jurisdictional error. He tried to distinguish the Cole and Allied case, arguing it was about different issues.
But did he have to concede they'd argued House v. the King below?
Yes, Justice Beach Jones pointed that out, and Walker SC conceded they had argued it that way in the FWC appeal, but suggested the correctness argument developed later.
Right. Then Justin Gleeson SC responds for the workers. What's his take?
He framed the Fair Work Act as deliberately shifting the balance, putting business decisions like outsourcing under tighter scrutiny. He argued Section 389(2's all the circumstances must include looking at contractor work if redeployment seems reasonably possible there. It's not about creating new jobs, he said, but reallocating existing necessary work.
And the dynamic enterprise idea.
He embraced it, said the FWC can and should consider foreseeable changes like expiring contracts. He pointed to the FWC's power to act on equity, good conscience, and the merits as supporting a broader view. Rejected the idea it was too complex.
And that sharp exchange with Justice Shaggett about preferring employees.
Yes. Justice Shaggett asked if his interpretation meant employers had to prefer their own employees over contractors. Gleeson SC's response was direct. In a word, yes. He argued the Act's scheme shows a preference for keeping people employed if the work remains and redeployment is reasonable. Redundancy shouldn't be a tool to just swap in cheaper labor.
A bold statement. And on the standard of review.
He strongly backed the federal court, said the 389 decision is evaluative, subjective, no single right answer. So House v. the King is the correct standard, consistent with Cole and Allied and other cases.
And he had that procedural point, too, about the company changing its tune.
Yes, a powerful point. He argued the company ran the case for 4 years on the House v. the King standard to try and switch to a correctness standard only at the high court. He basically said on discretionary grounds the court should refuse relief. Enough is enough. You can't keep changing your core legal argument this late in the game.
Makes sense. How did Walker SC wrap up?
In his final rebuttal, he warned the court against what he called a path of subjectivity and hindsight for the FWC. He argued it could paralyze legitimate restructuring and scare companies off using contractors altogether.
And then?
The hearing ended. The justices reserved their decision.
Leaving everyone hanging.
Exactly. And as we record this, June 2025, that high court judgment is still awaited. The final word in this long, long legal saga hasn't been spoken yet.
The suspense. But whatever the high court decides, the implications are massive.
Huge. Legally, industrially. If they uphold the federal court.
Meaning if the miners ultimately win this point of law.
Then it cements that precedent. Employers making redundancies will have to seriously consider if they can redeploy staff into roles held by contractors, assuming it's reasonable in all the circumstances. You can't just ignore that possibility.
That would really force companies, especially in sectors like mining or construction, to rethink things, wouldn't it?
Absolutely. Much closer scrutiny of outsourcing deals, maybe needing clauses allowing flexibility to insource, more caution before making redundancies while contractors are still on site doing similar work. It could effectively give direct employees, a kind of legal priority.
But if the high court goes the other way, sides with Helensburgh coal,
then it draws a much clearer, probably narrower line. It would likely say that reasonable redeployment under 389 primarily looks at the employer's own established structure and doesn't require disrupting contractor arrangements.
which would be a relief for employers.
Yes, greater certainty for business planning and restructuring using contractors. But for workers in situations like the Helensburgh 22, it might mean no unfair dismissal remedy, even if their work continues, just done by someone else.
Either way, it's a landmark decision pending.
Definitely. But beyond the legal outcome, the story itself is something. These 22 men, their union, they fought this relentlessly.
From the mine site through the FWC twice, the federal court, all the way to the high court. It's an incredible display of resilience.
It really is. It shows what it takes for ordinary people to challenge major corporate decisions through the legal system. And it puts the spotlight right on how our laws, often written for older employment models, cope with the modern reality of outsourcing and complex work arrangements.
And it keeps coming back to that manager's quote, doesn't it? It's just not how we approached it.
That's the crux. This case forces everyone involved, companies, unions, tribunals, courts, to actually confront that approach, to ask, well, how should we approach it? How much weight do we give to loyalty, to fairness for long-serving employees, versus the perceived efficiencies of outsourcing?
The High Court's decision will give us the legal answer to how much consideration is required.
It will define the legal boundaries,
Yeah.
but the case itself has already forced the question into the open.
And maybe ensures that, going forward, those real people's livelihoods get more than just that cursory consideration.
One would hope so. The judgment will tell us exactly how much more the law demands.
So we wait. It's going to be fascinating to see how the High Court balances business flexibility and employee security in today's workplace. What will the ultimate legacy of Helensburgh, Cole v. Bartley be? That's the big question hanging in the air. A space definitely worth watching.